Good afternoon. My name is Roger Gibboni, and today I'm going to discuss automatic payment provisions as a condition to notice of non-extension in standby letters of credit. First, I'm going to discuss what automatic extension provisions and notices of non-extension are and what they do in standby letters of credit. Then I'm going to talk about some of the issues that beneficiaries and government beneficiaries in particular have with automatic extension provisions and notices of non-extension. Lastly, we're going to discuss a solution that has been suggested and imposed by some banks to deal with the issues that government beneficiaries have with automatic extension provisions and notices of non-extension. That solution is a automatic payment provision, which is the topic of this discussion today. And we're going to look at automatic payment provisions and talk about the legality and kind of the functionality of them and try to determine whether this is something that should become part of standard practice in standby letters of credit. So first, it's important to understand what an automatic extension provision is and what it does. An automatic extension provision is a provision of a standby letter of credit that is included in a standby letter of credit upon mutual agreement by the undertaking parties, if they choose to include one. And what an automatic extension provision does is it extends the period or life of the letter of credit for another agreed upon term upon expiration of the original term. So just to kind of clarify what that means. Typically, a standby letter of credit will have a term of 1 year, and upon expiration of that 1 year, if the standby letter of credit has an automatic extension provision, exactly at that time of expiration, the standby will automatically extend for another 1 year term. And this can go on for a number of years and often does, and the standby will have a expiration date that is agreed upon by the parties, at which point the automatic extension of that standby letter of credit will no longer occur. So there are a lot of reasons why banks have opted to use automatic extension provisions, and primarily they revolve around regulatory issues with banks having outstanding and prolonged exposure to a standby letter of credit that could change over a period of time. The underlying contract that can change, that conditions can change over a period of time. Another reason is that it's kind of prudent banking practice to reevaluate the applicant's credit annually from year to year. So typically, as I said before, but this is not always the case, typically a standby letter of credit will be from year to year and automatically extend, say, for 5 years in 1 year segments. But that can change depending on the contract terms. So what the reason, we know the reason for an automatic extension provision is because the banks want to have these, shortened periods of time that they can manage their portfolios better. But a lot of the utility of a standby letter of credits for the applicant's purpose and for the beneficiary's purpose needs to extend over the course of many years, and this accomplishes that. If an applicant and a beneficiary need a standby letter of credit for 5 years, they can do so over the course of 5 years, but in 1 year segments, so the bank can also get what they need. Now, what's important in a automatic extension provision is that it will also usually include a notice of non-extension provision. And what a notice of non-extension allows is for the bank, typically 30 days or more prior to the upcoming expiration of the standby letter of credit, gives the bank the opportunity to notify the beneficiary that it's not going to extend the letter of credit into another term. So although these automatic extension provisions allow for 1 year extensions, the bank can cut that off at any of those defined expiration dates. The notice of non-extension has to be in clear, unequivocal language, indicating that it has decided not to extend the letter of credit. So, one thing that is an issue with these are very functional and very, very, easy to manage provisions for the banks. But one problem that beneficiaries have had with automatic extension provisions and notices of non-extension, and particularly government beneficiaries, is the risk that they will not receive that notice of non-extension in time to draw on the letter of credit. So just taking a step back, when a notice of non-extension is issued, the beneficiary is given the opportunity to draw on the letter of credit so long as it presents complying documentation in a timely manner. So there are a few reasons why government beneficiaries in particular have concerns with monitoring notices of non-extension in automatic extension provisions. Primarily, it's because of the kind of bureaucracy of government entities and the fact that correspondence to government entities many times has to take place over the course of, it can go through many levels before it gets, a piece of correspondence can go through many levels before it gets to the correct person. So particularly with a notice of non-extension, that can be very detrimental if, say, an issuing bank issues a notice of non-extension 30 days prior to an upcoming expiration, and the correct person at the government beneficiary doesn't receive it until 32 days later, or never receives it because a mail clerk mishandled it for whatever reason and didn't know that this was something that needed to be timely handled and received by a specific individual in order to draw on the letter of credit. And this can have seriously detrimental effects. So, it's very understandable why a government beneficiary would have concerns about this. And government beneficiaries are a big client for a lot of issuing banks. So some issuing banks have proposed solutions to this to mitigate that risk. And what that proposal would do is, upon a notice of non-extension, rather than issue the notice of non-extension and give the opportunity to the beneficiary to make a timely presentation, would automatically pay the beneficiary, the government beneficiary. So this would kind of eliminate the problems with that notice of non-extension getting to the right person and the right person coming to the issuing bank and making a documentary presentation that complies and drawing on the letter of credit. That would eliminate some of those issues. So this is a novel concept. This is a concept that some issuing banks and commentators have said really shouldn't become a part of standby practice. So automatic payment provisions are proposed in Draft 3 of ISP 98 Form 11.1. And 11.1 operates under two conditions. So automatic payment would be made, this automatic payment provision would be fulfilled if two conditions are met. And that first condition is a timely and complying notice of non-extension, obviously. The second condition is that payment's made. So these are two very simple conditions that have to be met, but they're very significant. The notice of non-extension has to comply and payment has to be made. And most standby letters of credit that include an automatic payment provision will indicate that the standby is that the notice of non-extension is void if payment isn't made. So if payment isn't made right away, that notice of non-extension will be void, and if another one hasn't been made, that automatic extension could occur. So we look to regulations first to determine whether an automatic payment provision is something that can be used and should be used, and even more so whether it should be used as part of standard standby practice. ISP 98 Rule 9.01b and the U.S. Comptroller of Currency's Interpretive Ruling 12 CFR Section 7.1016b3b basically say that the ultimate effect of an issuing bank giving notice of non-extension is to terminate liability under the standby and thus sever the immediate relationship in the undertaking. So while this has a lot of potential and has potential to address a serious issue for government beneficiaries of them not getting their notices of non-extension, there are legal issues with it. And the most obvious legal issue is that an automatic payment provision is a non-documentary condition that would result in payment. So UCC Section 5.102.10 clearly states that a letter of credit is an undertaking by an issuer to a beneficiary to, among other things, and this is quote, honor a documentary presentation by payment or delivery of an item of value. So, when looking at Section 5.102.10, it would seem to indicate that an automatic payment provision damages the integrity of a standby letter of credit because there are conditions that are non-documentary. And this is why banks and applicants typically, and some drafters argue, should resist automatic payment provisions. But as we said, some applicants want them, and some beneficiaries want them, and some banks have agreed to issue them. So, just again going through some rules. ISP Rule 4.08 states that a standby with no specified documentary presentation requirement is deemed to require documentation for payment. And similarly, 12 CFR Section 7.1016a states that a bank's obligation under a letter of credit depends on a specified documentary presentation. So we have two regulations right there, ISP 98 and 12 CFR 7.1016, telling us that documentary presentation is a key element of a standby letter of credit. On the other hand, we have ISP 98 Rule 9.01b, which permits the issuer to terminate the standby upon reasonable prior notice or payment. And we have 12 CFR 7.1016b3b, which permits the bank to terminate the undertaking either on a periodic basis, consistent with the bank's ability to make any necessary credit assessments, or at will upon either notice or payment to the beneficiary. So that says something completely different. That says something that we would think an automatic payment provision complies with, and that automatic payment can be made. So at first blush, the regulations kind of conflict with one another on this issue and create a problem for automatic payment provisions. And that big problem is uncertainty. If parties choose to include automatic payment provisions, and something happens, who knows what rules and regulations will work. So what I did is I looked at some case law, primarily on the issue of documentary presentation. There's no case law on automatic payment provisions, as this is kind of a quirky and new provision and solution that is being used by banks and hasn't been litigated yet, as far as I know. And I first looked at a case that's kind of the foundation case of documentary presentation, and that's Wichita Eagle versus Pacific National Bank. This is a Ninth Circuit case, and the Ninth Circuit determined that the instrument that was in question was a guarantee and not a standby, despite the fact that the instrument was titled a standby letter of credit. And they determined this because, quoting, the instrument neither evidenced an intent that payment be made merely on presentation, on draft, or nor specified the documents required for termination or payment. The documents required for payment. So the court was basically saying that something other than, by the document stating that something other than documents alone were required for presentation, weighed against the finding that it was a standby letter of credit. The court in Wichita Legal further noted that the instrument was not a letter of credit because it strayed too far from the basic purposes of a letter of credit, namely providing a means of assuring cheaply by assuring cheap payment by eliminating the need for the issuer to police the underlying contract. And this was a very determinative factor that they looked at in determining whether this instrument was a letter of credit or not, which I found very interesting because first Wichita Legal tells us that the fact that there was a condition, a non-documentary condition, weighed against the fact that it was could be determined to be a letter of credit. But then the court tells us that it strayed too far from the basic purposes of a letter of credit, the basic purpose, providing a means of assuring payment cheaply by eliminating the need for the issuer to police the underlying contract. Now that doesn't seem something that would run in the face, or that's something that an automatic payment provision would run in the face of. In fact, an automatic payment provision probably makes the standby letter of credit, at least for government beneficiaries and the issuing bank, easier to monitor and ensures cheaply paying by not having to police that underlying contract. So again, we get mixed signals on whether something that is a non-documentary condition but not connected to the underlying contract and not going against the primary purpose of a standby letter of credit, whether that kind of provision damages the integrity of the standby letter of credit as a whole. Looked at another case called First National Bank of Aspen, and that court noted that the disjunction between a letter of credit and the underlying obligation does not prohibit including in the letter of credit itself non-documentary conditions which are relevant to both the satisfaction of the terms of the underlying contract and of the letter of credit. So that seems to say that you can have supplementary conditions in a letter of credit that are non-documentary without damaging the purpose of the letter of credit and the integrity of the letter of credit as a whole. So the case law, which there's more case law that's discussed in this article, the case law doesn't seem to clear up for us what the regulations left unanswered as well, which is, does this non-documentary condition create a instrument that is not a letter of credit because it strays too far, not from the purpose, but from what we understand traditionally as a letter of credit, which is something that relies on documentary presentation alone. For me, looking at the case law and the regulation, that uncertainty is very dispositive. It indicates to me that this is a problematic and kind of too unique provision to integrate into standard standby practice, into mainstream standby practice. The parties that use these, the issuing banks and the government beneficiaries, likely will continue to use these provisions at their own risk, and they should, because there's no reason for them not to if they agree upon those terms. But, you know, there are several scenarios where, not, at least based upon my reading of the regulations and some of the case law, where non-documentary conditions can be part of a legitimate standby letter of credit. But those are the exception rather than the rule. And to include a automatic payment provision into mainstream standby letter of credit practice or into some kind of model form would seem to make it the rule rather than the exception, and seem to go too far in accepting something that is a non-documentary condition for payment. Again, there's no reason why the parties who want to use these can't use these, but to include them in standard mainstream practice seems to create a problem. So that kind of sums up what my research was about. And again, just to go over it and kind of summarize it, it's important to understand what an automatic extension provision does, what a notice of non-extension does, and how those functions can really create monitoring issues, particularly for government beneficiaries. Banks, creatively and intuitively came up with a solution that provides automatic payments, so those banks never have to worry about a notice of non-extension not getting up to the right person within enough time to make a documentary presentation. It's a great idea, but to me, it creates uncertainty, and uncertainty in any kind of banking, and particularly in letter of credit practice, is not something that you want to integrate into standard practices. And people are free to contract, so they can continue to do so. But if this does come to a court of law, it is my guess that you're going to have to look at Wichita Legal, and again, it's just too hard to determine. I want to make a conclusion, but I don't know that I can, because it doesn't require documentary presentation, which is on the one hand weighs against, but it doesn't go against the primary purpose of a letter of credit, which is to ensure cheap payment by the issuer not having to police the underlying contract. So my conclusion in this research is that because of uncertainty alone, these should not become a part of standard practice or included in a model form. But they're not a bad thing, and probably should and will be continued to be put to use. So I thank you for taking the time to listen to me today. This is for Professor Burns' International Commercial Transactions course, and thank you very much. Have a great afternoon.